Well, welcome all to the last of 2023 Vermont Law School series in partnership with Financial Futures at CVOEO. The topic we'll be covering today is what's in a good contract and why do they go wrong. We will be continuing the series in 2024 on January 23rd from noon to 2 with the Financial Risk Management webinar. Next slide, please.
Oops.
This recording will stay on throughout the whole video, so please mute yourself when you're not speaking. Enter questions into the chat. Simeon and I will try to get to them. If not, Nicole will also be monitoring. And after the workshop, I'll make sure that you receive this presentation along with any links to resources that we mention. So without further ado, I'll pass it over to Simeon Geigel.
Great. Thank you, Sophia. Welcome, everybody. I'm so glad you could attend today's class. I think class on contracts is really, really important and good for everybody to know, especially in business, and I look forward to learning as well. I'd like to just provide a brief introduction to the Micro Business Development Program in case you are interested in taking advantage of our services. So the Micro Business is a statewide program started back in 1988, and we work with low to moderate income Vermonters to help them start or expand a business. There's no cost or fees for our service as long as folks meet our income eligibility guidelines. So if you're interested in knowing if you qualify, don't hesitate to reach out to myself or one of our other business counselors here at CVOEO. Those counselors are myself, Simeon Geigel, John Gergley, and Pacific Sangayuva. Specifically, micro business covers Chittenden, Franklin, Grand Isle, and Addison County. So if you live in those areas or operating a business in those areas, feel free to know that we are the correct contacts for you. Next slide, please. I mentioned that the program is statewide. If you live in any counties outside of the ones that I listed, you can see the appropriate micro businesses that cover the other counties around the state and the correct contact person. We have Brock that covers Bennington, Rutland, Capstone, which covers Washington, Lamoille, East and West Orange counties. We have NECA that covers Caledonia, Essex, and Orleans. Currently, SEVCA does not have a counselor at this time, but they are in the process of hiring somebody for that position. And you can also go to the website, general website for our programs at mbdt.org if you want to connect specifically with one of the folks that covers the different counties for our program. Next slide, please.
Is that not the right slide for you? I'm sorry.
Nope, you got it. That's right.
Okay.
I do always like to point out that there are other wonderful business development programs out there that work with people and help people in their business. Some of these are specific to the counties that we serve, but a lot of them, if not most of them, cover the state. Specific to Burlington, we've got Burlington's Business and Workforce Development Department, the Center for Women in Enterprise, Mercy Connections, the Women's Small Business Program, the Vermont Small Business Development Center, SBDC. The Small Business Administration is listed here, but that's a federal program. And of course, finally, we have Champlain Valley SCORE. SCORE stands for Service Corps of Retired Executives. So let's get to why we're all here today. So today we have some great presenters. We have Nicole. Now I had stage fright with your name, Killoran, and so Nicole is the professor of law and the director of the entrepreneurial legal lab, and we have Devin Brennan, a student from Vermont Law and Graduate School, and VCEL's Community Navigator Program page, and maybe Nicole, you could speak a bit more specifically.
So the VCEL Community Navigator Pilot Program is not joining our consult today, but they are. This is the address for our page if anybody wants to request services, and I'll go over those in a little bit too. towards the end of the slides, but this is the address. If you wanted to request legal services or legal education, that's what we provide. And that's the address where you go to find it.
Great. Thank you, Nicole.
With that,
Appreciate it.
yeah, I think we'll take it away. So here's our agenda for today, folks. We're going to cover 4 main topics. What is a contract and what are the important parts of it? We're going to try and give you some examples from different industries and different contracts to help illustrate some of these issues and these questions. So what are the common contracts? What industries do they go into? What are the clauses that folks should understand? And then the second half, we're going to focus on not how to build a good contract, but why do they go wrong? Common reasons they go wrong, and then what happens when they do? How do disputes get resolved? So that's the agenda for today. I'm going to hand it over to Devin, who's going to start us off with what the heck is a contract anyways?
Hello, thank you. I will briefly talk about what is a contract. A contract is an enforceable statement of a bargain. A bargain is an exchange or a give and take between at least 2 parties. And I said enforceable statement, meaningful, effective contracts are enforceable. Unenforceable contracts are meaningless or ineffective. For the terms of an agreement to be understandable, the contract needs to be stated in reasonable detail, usually in a document. But note that at least some verbal contracts are enforceable. The parties to the contract have to accept it, which usually means signing. Electronic signatures are also okay. Even click-through agreements, all those end-user license agreements, terms and conditions, you say to yes alone, those are enforceable. Sometimes contracts contain seemingly odd provisions. Usually contracts can contain even seemingly odd provisions, but enforceability remains an important question. The United States has very broad freedom to contract. If a contract contravenes or goes against public policy, courts will usually not uphold those contracts or certain provisions of those contracts. An example of a contract against public policy might be signing one's statutory rights away in a residential lease as a tenant. Next slide, thank you. I'll talk about what's in a contract. There are 4 main parts of a contract here. First, the core deal or the transaction details. The core deal covers the details of the transaction. Lawyers can fumble here. There's a lot to consider. For example, how many widgets, what color are the widgets, where are the widgets delivered, who's delivering the widgets, when are the widgets received, by whom, what price. So there can be a lot of details in a contract. The other parts, lawyers might provide better help. Historically and currently, lawyers help resolve broken contracts, which with time has helped lawyers identify common parts of contracts that offer protection and help mitigate problems or conflicts. The second part of what's in a contract are aspects that help facilitate the transaction. There can be complicated aspects of a transaction, and these supports, promises, and assurances can help that. So for example, people usually don't want to buy property with an active zoning violation or property that the seller doesn't clearly own. So buyers usually ask sellers to promise that the seller has clear and clean title to the property. And buyers usually ask sellers to promise that the sellers take some responsibility in case someone else claims otherwise. Third part of what's in a contract are provisions that can protect clients and distribute responsibilities. We'll talk about this a little bit later, but for example, indemnification or hold harmless provisions or provisions on dispute resolution. And the fourth part, finally, in a contract are procedures. Where to send goods, when someone needs to change something, what state law applies in case of conflict. So these 4 main parts, details, support, protections, procedures, are what's in a contract. Next slide, please. Thank you. Here are some common contracts in business. I'll talk about each of these just briefly. Anyone taking out a loan will usually sign a promissory note. It's a document specifying a promise. Anyone incorporating will usually need a signed governing document, for example, an operating agreement or bylaws. Anyone providing services might specify the scope and terms of those services in a service agreement. For businesses with employees, employee agreements, although not too common, can be useful to explain the terms and conditions of employment. Employee handbooks can contain promises that create an implied contract. Beware of these promises. Licensing agreements can give others rights to use one's intellectual property. For example, a license to use copyright to duplicate copies of protected intellectual property. Non-disclosure agreements, common business contract, can constrain what information is disclosed. They can affect types of information a person can reveal, in other words, and they can be separate or part of a contract. As part of a contract, for example, an employment agreement. Bills of sales help prove title or ownership and often accompany something sold, like a product or item, service. And non-compete agreements can prevent someone who leaves a business from immediately working for a competitor of that business. But the Federal Trade Commission is leaning towards disfavoring non-competes. So exercise caution when using a non-compete, and also see about using confidentiality agreements for similar purposes as the non-compete. Thank you.
There was actually two at the top that you skipped. Do you want to go back to those, Devin? These are two of the most common ones that folks are going to see.
Yeah, some contracts are common across all industries, and these are not exhaustive, but leases are definitely really important. I missed that one, sorry. Almost everyone faces a lease at some point in their lives. Leases can cover property, space, equipment. These contracts are common. I'll also briefly cover a purchase and sale agreement, loans. High value assets like property or business are generally bought with a purchase and sale agreement, which specify steps needed to be taken before the transaction closes.
That was the last one. I think you got the promissory note at the beginning of it.
Thank you.
Cool. I'm going to give you some examples of what different contracts might go into different businesses. I hope that this helps illustrate a little bit how different businesses really have different concerns, different risks, and they have a different way of interacting with vendors, with third parties, et cetera. So you're going to see different agreements come up in different contexts. So for example, the healthcare, the health and wellness industries, very common in these industries to see things like a waiver of liability, to have somebody come in for a massage, for example. The massage therapist might want to have a client sign a waiver of liability that says, I understand there is an inherent risk of injury with massage. I am accepting that risk as the client, and I will not sue you, massage therapist, as long as you're behaving reasonably. That's just an example of a way that a business owner can try to control liability or control risk for themselves, to put into a document that they're not going to be liable because the client should understand this is the risk they're taking and they've been informed. Creative industries, sorry, I also want to mention, obviously, healthcare industries are going to have to worry about HIPAA. Data privacy is a big thing in any of the healing arts. Consent form is something that most folks will find in a practice where there is direct touching of clients. If there's any need to put hands on another person for a healthcare practice, typically going to have a consent form that says that the doctor or the nurse or whoever it is gets to do that. Creative industries, they interact with intellectual property a lot. That seems obvious, right? But how that factors into the work that they do comes a couple of different ways. Creatives are likely going to see licenses for intellectual property rights, which is the ability to use one's rights. They likely are going to see something in an agreement. If they are producing work for another person, there's something called a work for hire agreement that has to be put into a contract that says that if someone is producing materials or work for another person, then the other person gets the rights to the materials that are produced. That has to be in a contract to be enforceable. Otherwise, those rights stick with the person who made the stuff. But creatives definitely are going to run into that at some point in time. Construction and property industries, obviously, there's usually for at least bigger construction projects, there's going to be a construction contract, possibly subcontracts. This is an area where there's becoming more regulation. The state just instituted a baseline requirement for what will go into contracts for folks who are doing home repairs or homework. So handymen, basically, people who have a broad set of skills and they're going to go in and do some minor work for homeowners. They now have to have basic terms in a contract, and they have to use a contract with the client if they register with the state. Services and consulting industries, those are obviously going to be services agreements, something that spells out what the services are that are being provided, and then possibly include some terms and conditions that go along with those services. Online sales, anybody who sells online, it can be very complicated. If it's within the state, there may be less concern about interstate interactions or sales tax, things like that. But online sales, the big things for them are probably going to be a privacy agreement, something that that they offer up on their website to say that information is kept private, what information is private. In terms of service, probably if there's an online sale, there'd be something, that click-through agreement like Devin mentioned, that could be used on a website. And then just disclaimers. I see those all the time for online sales, that this is what's being sold and this is what's not being sold. And then finally, people who are developing products. This is a big portion of the economy, obviously, and this includes a lot of different things. But product development itself involves intellectual property. So here again, we see licensing, we see agreements between parties saying you can use my copyrighted material, you can use my trademark, you can use my patent. There's also going to be potentially agreements with people who will make products, so manufacturers. Important there to have some sort of a protection back and forth or there may be just a separate agreement with a manufacturer that says that if a manufacturer makes an error and hurts someone, then the manufacturer will hold the designer harmless. We see that sometimes too, just a separate indemnity agreement. So those are some of the common contracts for different businesses. I want to pause right now to just to see if the couple of folks who are able to join us, if you guys have any particular industries that I didn't cover that you might want to think through, like what are the common contracts for those? And if not, I'll just move on.
I have a couple of questions.
Sure.
One is food. Question about the contracts that are pertaining to food. That would be great.
Okay. So it really varies. So restaurants typically aren't going to have like a contract, but if you provide catering, for example, that really sort of falls under, in my eyes, let me go back just one slide. That falls under a services agreement in my interpretation, but there's a couple of extra things that would go into a catering contract, or really any contract where there's a potential risk for someone to get hurt in the course of offering that service. Though typically in those, it typically is going to be a services agreement, and typically the indemnification is going to be a big important part of that contract to say if there is, for example, for caterer, if they're holding it at a venue, if something happens in the venue, there probably will need to be an agreement with the person who has the venue where the event is being held, to say that if someone falls off a ladder, it's not the responsibility of the caterer, for example. That's what I see the most often when it comes to those types of agreements. Is there another context though that I'm missing? Is there another type of food business that you were thinking of?
It's actually alcohol, so beer.
Yes, there's some special licensure for that. Obviously, you most likely already looked into that, but yeah, like what comes to mind for me is possibly just vendor contracts. So folks who are delivering goods, maybe there's some sort of a contract that's signed with them, but I don't typically, I haven't worked with many people who sell alcohol to be honest with you, except for through restaurants.
Okay.
So
all right, thank you.
Yeah, no problem.
The other one that other question I had was around partnering with other people so that you're co-owners and the navigating contracts and things like that as co-owners.
Right. So there's a couple of different things in there to talk about. This is something I learned yesterday. There is a limited contract, which is something that describes a transaction, 100 widgets, blue color, delivered on this date for this amount. For transactions, it's usually there's lines around it, it's bounded. But there is another type of contract, which is the one that you're thinking of, Leah, which is sort of an unbounded contract that governs a relationship. And that is what is generally signed by folks who are going into business together. There's a couple of different business entities that something like that might fit into. Someone can be a sole proprietor if they're just one person doing business and they're not incorporated, they're not formal, they are the business itself. If they bring on someone else, but they don't want to file something with the Secretary of State, they want it to be informal still, they enter into what's called a partnership by default. Still, it's just two people who are doing business together. We start to see contracts that really govern how things happen within a business entity. Typically, those kick in when someone files for a limited liability company with the Secretary of State. And if someone files as an LLC, they only have to do one simple document with the Secretary of State, which is Articles of Organization. But then there is a separate document, a separate agreement with multiple people who are in a business entity that says this is the rules that we're going to follow while we're running this business together. That operating agreement is something that is it's somewhat DIY friendly. If someone wants to go to a legal Zoom or just find a form online, it's possible to find a decent form to work with. But then it's really important to have an attorney looked at. It's almost more important for someone to think through with their business partner what's going to go into an operating agreement than it is to have a perfect form. Because you have to work out details like what happens if you die, what happens if you want another person to come into the business, what's their contribution going to be? Are they going to have to put in as much as the original two people did? What if someone wants to leave just for any other reason? Is there a buyout requirement? Is there a first right of refusal? What happens if someone, this is an example from a student of mine who owned a business. They had a partner they had to kick out because the partner was drinking their profits. And so what happened, like if you don't put anything into an operating agreement, the law doesn't protect that. The law doesn't provide procedure for that. So this is sort of a roundabout way to address your question of that is the type of contract that brings another person into a business entity. And I think you have a second part of that.
No, that's perfect for right now. I think that's great.
Cool.
Thank you.
Simeon, did you have a question?
Yeah, I think maybe you already spoke to this to some degree, but what happens if, if part of your work depends on Mother Nature, right? And so maybe you have a catering event or you have a product that is sensitive and like there's a frost or something like that, and you have a contract to provide flowers or something to that effect. How would you deal with that particular kind of?
How would you deal with that? And Devin, jump in here too if you have any thoughts. To me, that says there needs to be an out clause. There needs to be something that's similar to like a disaster or force majeure clause. Force majeure is something, you can probably see it on the slide here. Force majeure is something that kicks in. If it's in a contract, it kicks in when there is a catastrophe that makes performance impossible. So there is sort of a default under the law that says that if it's completely impossible for the parties to a contract to do anything about it, to actually go through with the contract, then the contract ought to be void. But that takes going to a court case and enforcing that, and nobody wants to do that. So what people do instead is put into their contract, in the event that there's a catastrophic failure of crops or that the crops fall under this level of capacity for delivery, or we only are able to deliver this amount or whatever it is, this is what will happen. This will be the procedure, or there will be no obligation, or this contract will be whatever it is. It really is broad and free to be able to say, if this happens, this is what I want to happen. And unless it's clearly against public policy, if it goes to a court, it's probably going to be upheld. But that is one way that one could deal with it, is just to say, under these conditions, we're done. We don't have an obligation under the contract anymore because we can't provide you something we don't have.
Gotcha. Thank you.
Farnes, go ahead.
I had a question. You mentioned verbal contract. How does it work? And because you have nothing to prove, and how strong is it, verbal contract?
Right. Do you want to tackle that one, Devin?
Yeah, I'll talk a little bit about this later, but there's a common phrase. I think it goes, verbal contract is as good as the paper it's written on. So really, ideally, you have a written contract. But Professor Killoran might be able to speak better about the enforcement of a verbal contract.
Yeah, so it's tricky. Verbal contracts can be enforced. There are some things that cannot be in a verbal contract that will be completely unenforceable, and those are limited. So it's a sale of land or property, not personal property, but real property, land and a house. There is something that a contract that requires a contract that's for over $500. So $500 is the limit. If it's for sale of goods for over $500, then it needs to be in writing to be enforceable. And then something that will take over a year to perform. So if somebody signs something on January 1st and it says performance will be complete on February 2nd the following year, that's over a year. That contract has to be in writing to be enforceable. If it's 364 days instead of 365 days, a verbal contract can be enforced. Usually within that, even if it takes like almost the entire year to complete the performance. When it comes down to it, how they're sorted out is just testimony. People get on the stand and they say, this is what the agreement was. And then the other person gets on the stand on the other side of the contract and they say, no, this is what the agreement was. And then the judge gets to sort it out. So it's messy. Lawyers hate it. We really don't like people to have verbal contracts because they're impossible to litigate. We think a lot about how to litigate things. So, I mean, to answer your question, verbal contracts can be enforced. We tell people to avoid them because they're very difficult to enforce. That said, let's just acknowledge the reality that sometimes it might be intimidating or it might be a turnoff for some customers to have written conditions or a written contract in front of them that someone's asking them to sign. So that's just a business decision that folks have to decide. Do I put it in writing and protect myself, or do I chase off customers because I have this big long contract?
Okay, so the limit is 500.
$500 for sale of goods.
Okay, got you.
Anything over $500 for sale of goods has to be in writing. Is that right, Devin? Can you check me on that?
Yeah, I think it has to be signed as well.
Has to be signed. That's right. Yep.
Gotcha. Thank you.
Yeah. Simeon, did you have a question?
Yeah, Nicole, it occurs to me, maybe this is just worth pointing out. It seems like we're kind of on the topic, but the Office of Professional Regulation now, they since I think it was April, maybe you could just briefly speak to this, but they have a requirement now for contractors. I think if it's a job that's over $10,000, that they are now required to have contracts now. Provide something in writing.
Right. I can't remember what the monetary limit is or what the floor is, but yeah, I was referencing that earlier when we were talking about construction contracts. You're right. There is a recent adoption into the statutes that requires that anybody who is performing work on a residential space, they have to have a contract. The contract has to be, and there might be a monetary limit on that. You might be right, Simeon. I'm just not sure. Has to be a written contract and it has to contain certain provisions. I can't remember exactly what those were, but it was things like, description of the scope of the work, very basic. Description of, oh, hi, Islanda. Description of what's going to be performed, of the payment terms, how the payment is going to be determined. Is it time and material? Is it a flat rate? What is it, right? So there's very basic requirements to go into those contracts. It's not even though, it's not a requirement that they have to have these contracts. The state said, okay, people who are handymen doing work on residential spaces, you will register. And if you register, you have to use this contract. It's entirely possible to not register as a handyman in the state of Vermont. But if they do, they get on this list and they sort of get this mark of approval and they have to use this contract. And it's actually going to be a way for people to boost their handyman business is what I think.
Thank you.
Yeah. Other questions on that? We can move on to look at some of the common clauses. Unless I've lost, did I lose I'm sorry, I lost the slideshow. Hold on a second.
Yeah, I'm not seeing it.
I don't know why it went down. We were just having so much fun talking.
I found a link. I believe it's about $10,000.
10,000. Yeah, you were right, Simeon. Okay, let me just get back to where we were. Common contracts and business. Okay, common clauses. So first one sort of goes to that deal or transaction that Devin was talking about. What's the scope of work? But more importantly, from a lawyer's perspective, what happens to change the scope of work? So this tends to be true for the services industries. What's going to be done? What services are being provided? What food is being provided? How's it going to be delivered? What's the cost? What's the way? What's the format? The time for delivery, etc. That's really important details that the business owner has. How to change those ends up being a point of litigation quite often. It's possible to have written into a contract just something really simple that says if there is a change to the scope of the work, that will be done at least 30 days before X date, or it will be done with a back and forth process or something like that. I emphasize it because anybody who has a scope of work that's in a contract for their regular business, it's really important to say what happens if you need to change that, because it shouldn't be fixed. And if you don't want to go into a brand new contract, the scope of work should just be amended to keep the same contract. Compensation is important. Obviously, this is what happens in a contract. Usually there's exchange of something for money, but it's not just what's going to be paid, who's going to be paid, how's it going to be paid, when is it going to be paid, and in what format. If there is a specific requirement for a deposit in a particular format, for example, that has to be followed to the letter if someone's going to stay in compliance with the contract. Intellectual property is a very important part of contracts, and you remember some of the industries that we went over in the last couple slides. Think about creatives, artists, people who are making things, product developers, even teachers sometimes. Creative and educational materials can be protected under copyright. Intellectual property is often addressed in contracts, and typically it's going to just say who gets the rights and or does anybody have rights to use intellectual property. That's usually what they look like. Confidentiality, Devin mentioned this as an alternative to a non-compete clause. Now, confidentiality clauses are usually upheld. Non-competes, as Devin said, are starting to not be upheld by the Federal Trade Commission. Who's going to keep the information private? What information is covered? How broad it is, and if there's any particular requirements for keeping information secret, those are all going to go into a confidentiality clause. Something to note, if someone wants to take advantage of protections for something called trade secrets, which is just information that a business has that's not really protectable as copyright, it's not protectable as a trademark, and it's not a patent. Information like client lists or vendor lists or things like that just are not going to be protected elsewhere. They can be put in a private or a secure location, and employees required to sign a non-disclosure agreement, an NDA, in order to keep those items protected as trade secrets. And then if somebody comes in and tries to get at that information illegally, then there's an action that can be taken to protect that information. Force majeure, we mentioned, if there's a catastrophe, this happened a lot during the pandemic. People who had this clause in their contract were very happy they had it because it got them out of contracts. Think about a caterer who has an event that they need to go to, or that they're contracted to go to, and they can't because there's a global pandemic and they can't show up in person. The force majeure clause says in the unlikely event of a catastrophe like this, the contract's done. Nobody has an obligation to perform under it. Indemnification is real important, especially for product developers, especially for anybody who is working with third parties or vendors where there is a potential risk for a client or a customer to get hurt. The most important, the easiest illustration I can come up with has to do with a manufacturer and a product developer. Product developer designs a product. I'll give an example that my student of mine found that was just horrendous. But a design flaw from, I think, the 1990s was a helical pool slide with short sides. And kids started flying out the short sides and getting hurt. So that was a design flaw. That was a lawsuit against the designer to say you should have raised the sides of the slide before you started selling it to kids. But on the other hand, so that would be a design flaw. A manufacturer who was creating those slides would want something in the agreement that says if a kid gets hurt or if somebody gets hurt as a result of the design, the designer is going to protect the manufacturer from anything that happens. If there's a lawsuit, if somebody claims damages, if there's an insurance claim, the designer is going to hold harmless the manufacturer. It's not their fault. And vice versa. If the manufacturer uses the wrong bolt in the slide, for example, and it falls apart, the kid gets hurt, that there would be protection the other way. So the agreement might also say have a mutual indemnification that the manufacturer will also indemnify and hold harmless the product developer against any injuries that might happen as a result of a manufacturing error. So that's a really important one. I spend time on it because if there's any sort of risk in a business owners want to distribute that, and they usually want to send it to somebody else. And an indemnity or hold harmless clause is one way to do that. I'm going to pause there and see if there's any questions on the ones that are on this slide. Simeon.
Yeah, it might be a bit obscure, but with the last point, if you were holding an event on your property and inviting people to participate, would it be appropriate to have them sign an indemnification and hold harmless?
That would be something that my suggestion would be to sign a waiver, have them sign a waiver instead. Indemnification is typically going to be in a contract that's more of a long-term arrangement. But for somebody who's entering onto property or entering, this is an example I had from last year, somebody who had just a gorgeous property up in the mountains. They wanted to turn it into a wedding venue, but they had these areas of the property that were ledge, that were steep, that got slippery. And so every guest that comes onto the premises has to sign a waiver that says, we have ledge, we have spots on the property where it's slippery. We've marked all of them. You are required to pay attention to the signs and respect the boundaries. And if you do not, you may get injured. We are not responsible for your injury. Sign here. So that's typically how that risk is dealt with. Indemnification is usually going to be, it's similar, but it's saying, I'm going to protect you instead of saying it's your problem.
Gotcha.
Does that make sense?
Yes, to me, I think it does. If it doesn't to others, please speak up and
Yeah,
say.
please ask clarifying questions because it may make sense to me, but not to everybody else.
I have a question. What about if you forget to write it? Doesn't your insurance will cover that if you forgot to?
If you forgot to write, like have a waiver or an indemnification.
Something like that. Yeah.
Insurance will cover some damages. Not all insurance will cover every damage. It's important for a business owner to have at least, like if they have a physical spot, if they have a shop, generally important for them to have general liability insurance, but that is only going to protect against things that one might anticipate happening in a brick and mortar building, like falling ice, like customers slipping on the floor, someone getting hurt in the store. That is generally covered under general liability. Someone getting hurt in a transaction, usually not covered under general liability, and that's where an indemnification provision would come into a contract. Think about that manufacturer and product developer example. They're going to have to have a separate liability policy that's geared towards that kind of relationship or that kind of business that is going to have pieces in it that protect against damages. So if somebody gets damaged with the widget, or if they get hurt with the widget, there might be a separate liability policy, insurance policy that says for particular products, the insurance will cover damages. Without having a waiver that says the customer accepts the risk, or without having an indemnification provision in a contract that says that I'll protect you, insurance has a little less guidance to go by, and they also have more room to deny a claim. If you can think of terrible things that might happen, you would be surprised that many of them are not protected or covered by insurance. Think about property insurance for anybody who suffered through the floods this summer. Floods are excluded from most insurance policies intentionally. It's a big pocket of money. It's a lot that the insurance has to pay out. So they typically say if it's flood damages, we're not going to cover that. We'll cover earthquake, we'll cover fire, we won't cover flood. Flood is a separate insurance policy. So that's just an example of where the insurance companies sort of separate out. They put different policies. They also like to make you pay for different policies to get different protections, right? But they'll only cover certain damages under certain policies, and they like to exclude a lot of them. I don't know if that answers your question, though. I'm sorry, Farnes.
Yeah, it's just like there's so much you can predict might happen, and you might forget to write it, and
Yeah.
then it happens. And
Yeah.
then what happened? What do you do?
Right. If there's some sort of a lawsuit, I mean, what happens is somebody gets hurt and
Mhm.
figure out who's responsible and what the damages are. But if there is a waiver, then it's probably going to make the insurance company happy, because the insurance company has a piece of paper that says we're not responsible. They signed a piece of paper that says they're responsible. So it really is it's sorting out. There is some protection from insurance. There is some protection if somebody forgets, if they don't have the form, if they don't have the contract. There's a lot better protection if they do have those things in place.
Mhm. I think you need a lawyer to help you write a contract. There's so much details involved.
I know. Like we were saying, like Devin said, the details of the transaction are what you guys are really good at. Lawyers are terrible at that part, but we're very good at seeing risk. We're very good at seeing what could possibly happen that could hurt our client,
Mhm.
and trying to write into a contract something that will prevent that harm from happening. That's what lawyers are good at. And it's just because we see lawsuits. That's our job. We see things that could go wrong, you know?
Okay, so it's better for beginning, have a lawyer to go over it with you, help you write one, right?
It is there.
Oh.
It's always possible to write your own contract. A lawyer is going to be very useful to review it to make sure that it is one, legal. The example that Devin gave was a residential lease. If someone tries to put into a residential lease things that are against the basic requirements under Vermont law, that can't be enforced. It's always possible. A lawyer's going to be able to look for things that you could add to a contract that would protect you, ways to phrase things that might be more effective if it's challenged. They can think of things to put in there that you might not have, that they've seen before. They can be a really good resource just to do it. But if you come to them with a form, that saves you a little bit of fees, saves you a little bit of time. It gives them something to work with. That they usually appreciate that.
Okay, great. Thank you.
Yeah.
Nicole, I
any
have
other
a
questions?
follow-up question.
Yeah.
Yeah, sorry, I have a follow-up question. I don't know if you were planning to talk about this, and I don't know if there's any differences between a waiver and a disclaimer. But to what degree are those enforceable? You know, I've heard contradictory things over the course of time, and I don't know what's correct. Like, a disclaimer is enforceable or it's not. Is a waiver enforceable or it's not?
Right.
So are you able to speak to that to some degree?
Yeah, I think by disclaimer, you're referencing somebody who's just claiming an interest in something. Is that right? Or saying that like they don't, they're just
Oh,
disclaiming responsibility.
yeah, it's probably trying to avoid responsibility. In a way, I think about it like the waiver example that you gave.
Yeah, yeah.
You know, if you slip on the ledge, I told you it's slippery and you slip, that's on you. But I mean, if the person really gets hurt, and it's still on their property, I mean, what is the enforceability in reality?
So there's enforceability is good for ordinary negligence. Ordinary negligence is so negligence itself is there's a standard of care where reasonable people are expected to take care of other people. They're expected to do things to prevent injury to other people. Something happened, and as a result of that, someone is injured. That's a basic negligence claim, okay? That someone failed to take reasonable steps to protect, and someone got hurt as a result. There is a difference between ordinary negligence, which is what I just described, and gross negligence, which is where someone where someone disregards a risk to someone's body or life, that public policy dictates that there has to be higher enforcement on that. An example is somebody who has a gym who sells memberships to elderly patrons, but they don't have a defibrillator on the wall, and one of their patrons has a heart attack. That can be considered gross negligence because they could have reasonably anticipated they would have elderly patrons. They could have reasonably anticipated needing to have a defibrillator on hand for exercise. That is an example where it could be considered gross negligence. If someone had not put up signs on their property and someone fell down a 15-foot ledge, right? That might be gross negligence if they knew that the risk was there and they knew that they needed to do something about it, but they took no steps to prevent the injury. That could be gross negligence. I say that because ordinary negligence can be waived. Gross negligence cannot. So it's, if there's a known risk, if the document explains with enough specifics what the risk is, and then the client signs it and even maybe initials next to the risks that are spelled out. That's one way that folks do it, to say, look, they looked at this, they initialed next to it, every single one, they said they accept this risk. That should be enforceable, unless the circumstances of injury were such that they really were just a big idiot and they should have done something to prevent that problem. Does that make sense?
Yes, it does. Thank you. I appreciate it.
Yeah. It's basically like, we'll protect you up to here, but if you're really a jerk, we're not going to protect you.
Right.
So, okay, so let's look at some of the other common clauses, and then we can look at the next stuff that we have. Why do they go wrong? That's our next part. So I'll just run through these. We just talked about waivers. I won't touch on them in too much detail, but very common in the healthcare, sports, health and wellness industries. This is again where the customer is agreeing to accept the risks. I will often see this in the medical context, for example, for a procedure where a doctor says in one form, okay, patient, you are agreeing that you consent to me performing this procedure, which will require me to touch you. You also understand that this is a risk, this is a risk, this is a risk. You're going to initial next to every single one of those risks to show that you read this, that you understand this is a risk. You could get hurt this way, you could get hurt this way. And at the bottom of it, you, by signing below, despite all of these risks, which you now understand, you are accepting the risk and you will hold us harmless. So I say that actually using those words, Simeon, coming back to your last question, it is sort of a hold harmless agreement. It's just a special kind of hold harmless agreement. Dispute resolution. This is a really important one, but that's just because I've seen things go terribly wrong with the lack of dispute resolution in an agreement. How are conflicts going to be resolved? And when does it go to court? At what point do the parties stop trying to resolve disputes informally? And at what point do they just go to a lawsuit? It's very common in dispute resolution clauses and contracts to see a process that basically says they'll try to work it out if there's a problem. Next step is mediation, where there's going to be a third party who might try to work out an agreement between them. Next step is arbitration. That's the typical path for most contracts, especially if you're getting into a contract with a bigger business. They'll usually have an arbitration clause in there, and Devin's going to talk about this in a little bit too. Governing law and jurisdiction. This can be important because especially if someone is selling to someone who is in another state, it's important to say in one's contract that the laws of the state of Vermont and any disputes will be heard in Vermont. If without that in there, if a Vermont business sells to someone in California and then there's a dispute over the contract, that Vermont business is going to have to file a lawsuit and go to court in California if they don't have something in their contract saying that Vermont will be the venue. And then finally, termination, severability, and incorporation. These are just little tricks, lawyer tricks that we put into documents to say, by the way, this is what happens to end the contract. If these conditions are fulfilled, then the contract is null and void. That's termination. Or to say that this is what's going to spell out the end of it. Severability, this is usually what speaks to whether there's things that are sort of floating out there outside of the contract that might be brought in, or if there's things that will continue on after the contract goes away. Often confidentiality requirements will continue on after a contract is over. If it involves information that people want to keep private, there will be an ongoing requirement for whoever has that information to keep it private. And then incorporation is a little trick that lawyers use to say if there's any other agreements outside of this one, they don't matter because the entire agreement is within the four corners of this document. So common clauses, I know that was a lot of information. I'll pause again and see if anybody has any other questions about some of those clauses, and then we'll move on. Okay. So why do contracts go wrong, Devin?
Well, there are a few reasons, at least 7. Here are some common reasons contracts go wrong generally. I'll go through these. First, although seemingly obvious, lack of a contract is fairly common. So not having a contract or not getting the contract in writing. does not realize or create the contract. Side agreements and verbal amendments to agreements are common. So like spoken promises. Spoken promises make it hard to prove who said what and what the intent was. Written documents avoid at least some of the problems with spoken promises. Like I said, a verbal agreement is as good as the paper it's written on. Not reading the contract or accepting standard form. Contracts abound. Contracts surround us pretty much all the time, and many people don't read the contracts. But fine print can get you. Anyone who agrees to a contract is expected to have read and understood that contract, especially in cases where someone sues. Lack of specifics, insufficient specificity. It's a common problem, especially with dispute resolution, intellectual property, and ongoing obligations. For example, confidentiality that continues after a contract ends. And specific is terrific. Sometimes contracts have multiple drafts with various signatures and revisions, which can make it difficult to enforce the contract. How does a court determine which part holds when conflicts occur? Another common reason is not getting a signature. Sign your contracts. If a contract involves a sale of goods more than $5,000, if contract involves sale of property, or if contract will take more than a year to perform, law requires that contract to be signed to be enforced.
And it's the 500. I think you actually said 5,000.
Oh, did I say $5,000? $500. Thank you.
No worries.
So under those three conditions, though, you need a signature to enforce the contract. And then finally, changes in circumstances can cause problems. Things happen, and sometimes that's why people pivot, back out of a deal, or renege on a contract. And these are some of the reasons commonly contracts go wrong.
Thanks, Devin. In specific situations, I wanted to put this in there just to highlight what are the common areas where things go wrong in particular contracts. And you can see up here at the top, Leah, the one that we were talking about earlier, operating agreement and bylaws. Operating agreement is for LLC, bylaws is for corporation. Very common to see disputes about how do people get in and out of the business? What are the conditions for entry and exit? And that includes, what happens to folks' contributions to the business, to the capital. What happens if there's a death and there's an estate? These things are very heavily litigated. Like how someone's contribution is valued if they're putting some money into a business, that's heavily litigated as well. And then things having to do with the board. What responsibilities does the board have? What are their limitations? What can they do and not do? And as the board protected against some liability itself. So we see a lot of issues around those particular things in operating agreements. For the creative industries and product developers, we see a lot of issues around intellectual property, either failure to be clear, copyright and trademark are intellectual property rights that could attach in certain circumstances without registering with the federal government. But registering with the federal government brings a whole layer of protections and rights and responsibilities onto someone who holds a registered mark or a registered copyright. Not having an idea of who is using your materials, not registering for one's copyright, not registering for one's trademark. Those are very common issues for creative folks. We see people whose work is being taken without their permission. We see people who are just out there living their lives, and they get an email from a trademark troll or a copyright troll who says, "Hey, you're using my stuff and you got to stop doing that." We see these issues all the time for intellectual property in creative industries. And also just the details in a license agreement. A license agreement being an agreement between two parties saying one person has the right to use the other's intellectual property and under what conditions. What goes into those details is really, really important for creative folks. it's not just that someone has the right to use their copyrighted material, it's also for how long, to what extent, how many times can they use it, in what context, you know, are there any limitations? Like if it's shown to children, does that end the contract, or does that end the license, for example? That's a weird example, but it's possible to write that into an agreement. Construction and consulting and services agreements. These are I already emphasized this earlier, written change in scope agreement, a clause that says how to change the scope of the work that's going to be done. Super duper important for these industries because there's so much litigation that happens. And just, to go back to your question, Fernaz, this is another area where if there's a verbal agreement, someone has a construction contract and the homeowner comes back and says, no, I really want this to be the work that you do, and they don't follow up with an email, how do you prove that agreement in court? And if there's a written contract that contradicts that, then the person who's claiming they're owed money, it runs into a lot of difficulty. Prompt Pay Act is something I mentioned because anybody who's in the construction or handyman industry, there is a set of statutes that dictates when someone performs work on another person's, performs construction work, and there's a construction contract in place, there is a set of statutes that dictate how quickly someone must be paid, how disputes are resolved. People who are on either sides of a construction contract that have a dispute under the Prompt Pay Act, whoever substantially wins the case, who is like the 51% winner of a case, may actually get attorney's fees. So that's something to be aware of for folks who are in those industries, construction, consulting, services. It's just really important to make sure, especially in construction, to make sure that there's an awareness of rights under the Prompt Pay Act. For events and people who are doing events, force majeure is big. That's the one that lets, if it's written correctly, lets someone out if there's a big disaster or there's a pandemic that makes performance impossible. For manufacturing agreements, this is where, again, indemnity needs to be in an agreement for product developers or manufacturers. Who is going to protect whom against damages if somebody gets hurt? It's going to be really important in that context. And then commercial leases. We're seeing so much of this after the floods this summer. I've got a list here, but I actually want to add to it failure to put protections in place for the commercial tenant period. Build outs. So I'll go through the list here. Commercial leases, build outs is so if anybody enters into a commercial lease and they need to redo the space inside for their business, then that's what we call a build out. Build outs need to be written into a commercial lease. A lot of this is because there's no defaults for commercial leases under the law. It's all a matter of contract. So, for example, if a person is going to be moving into a commercial space and they sign a lease that says that the only thing the landlord is going to provide is the primer, that's all that the landlord has to provide. And the business owner gets to provide the paint, the baseboards, the light fixtures. Everything that's in the contract is what can be enforced. And landlords I have seen get very squirrely to leave stuff out of their leases that they don't want responsibility for. And unfortunately, they have a position of bargaining power that's usually much higher than the tenant. Build outs are a common issue. We see a lot of litigation around like what could you do when you entered into the space in the first place? What happens to the common space? Who maintains that? Who's responsible for paying if there's a problem in the common space, falling ice or slip and fall, for example? Liability and indemnity, who's going to protect who? I always want to see commercial tenants put a mutual indemnification clause in. If someone gets hurt in your shop, you'll protect the landlord. If someone gets hurt outside on the landlord's ground, you'll protect the shop owner, etc. I always want to see something mutual for commercial tenants. Attorney's fees are really important in a commercial lease because if there is no listing of attorney's fees mentioned in the contract, nobody is entitled to have the other person pay for their attorney. If attorney's fees are mentioned in a contract, if there is a litigation, then the attorney's fees might be paid by the other party who loses. But if it's not in the contract, and often landlords will write in that they get the attorney's fees if they win, and they'll just leave it silent as to the tenants. Failure to mitigate. This is a default that applies to any lease. Anyone who is a landlord who loses a tenant before the end of the lease has to take reasonable steps to put another tenant in that space. If they don't take reasonable steps to find another tenant, then the amount of money they can claim from the tenant who stepped out, who broke the lease before, is pretty limited. They have to show that they're trying to advertise, that they're trying to find another tenant to move in and pay the rent. And whatever they receive from the new tenant will be reduced against the previous tenant. But if that's not, that has to be put into a contract, the process. And there might even be requirements for specific steps that have to be taken to find a replacement tenant that could be put into the contract. I'm going to add one to this list, which I'm seeing so much this summer after this summer's floods. Habitability. This is the concept of having a clean and safe space to be in. It's written into the laws for residential contracts, for residential leases. That's people's homes. If someone is renting for their home, the law says that the landlord has to provide a habitable space, water, hot water, heat. Those are the basics. But then if there's safety or health concerns, there's a process. There's nothing for commercial leases. And I can't tell you how many business owners right now are being told by their landlord that they have to get back into their space or they're breaking the lease when the space is infested with mold. That's happening. And technically, if there's nothing in the lease that says that if the space is infested with mold or otherwise has health or safety problems, that there's no obligation to continue the lease. But that's not written into most of these leases. They're silent. So people are having to decide whether to break their lease and take that risk or to go into a space that's not safe for them. So really encourage people to write that into their commercial leases if they have one that they're looking at. I think we'll go into dispute resolution before court, but I just want to stop and see if there's any questions. Parnas, go ahead.
Is there a time period after you sign a lease that you can change your mind and say no? I know when I signed for my car lease, there was, I don't know, 2 days you could change your mind.
That's in the contract. So it would be written into the contract itself. It's not a default under the law.
Oh, okay.
It would be language in the contract that says there's a 2-day grace period, or in the event that someone decides against this transaction, they have 2 days to reverse it or something like that.
Okay.
It might be possible to have that written into a lease to say, that there's 2 weeks from the date that the draft is delivered to decide whether to enter into it, or like a 2-week out period. But that has to be written into the lease.
Okay. And how does the e-signatures work? Like I know for my car loan, I just signed it on the computer, but anyone else could have been signing for me. How does that work? How could you prove that?
So it's possible to just go into like Adobe and sign, right? That's one way to sign. There are a series of document signing services that are popping up right now. DocuSign, for example, that what they do is they create an electronic stamp every time someone submits that signature on a document. So that stamp says the time, it has an identifying number that's attached to it that can be tied back to, I believe that's tied back to that person's IP address.
Okay.
So that it can be, it's a very, they put that in there so that it's reliable, right? So that there's indication that this was actually signed by the person we want. And if there's a need to prove that they signed it, then we have this information to go back and track it.
Okay, great. Thank you.
That's typically how they do. But if you're just filling out an Adobe form and you sign it, like there's no way to really tell. That doesn't have that mark on it. Samia, did you have a question?
Yeah, I don't know if you're going to get to this or, to what degree it matters, but if you are on the receiving end of getting a contract, is there a better or preferred way to, if you don't agree with some aspect of the contract, to push back on the person that is giving you the contract? I don't agree to clause 3, subset B or whatever.
Yeah. So there's a couple things in here. One is that in the process of entering into a contract, of working out the details of it, it's important to know that someone sending over a document does not create the contract. It is an offer. If they send a document, if they send a contract and say, here's what I think we should sign, that's an offer. If there is a response that changes the contract, that's a counteroffer. That still means it has to be accepted. So I say that just to illustrate that there is a process and that the law considers that to be open until everybody's on the same page and they've accepted the terms and signed it. So while they were in that same time period of negotiating a contract, I always want people to push back and say, hey, I need a mutual indemnification clause, and I really need to have a habitability requirement here in the lease because I don't want to, what this happened to a lot of people this summer. I want to see that. Negotiating with a landlord or with somebody else on the other side can be tricky. Lawyers do it by just being blunt, by saying, nope, this is unacceptable. This is too risky for my client. I'm not going to take it. Need to take it out. Lawyers typically will, when they're talking to other lawyers, will be that blunt. When someone is not a lawyer and is speaking to another person who's not a lawyer, I have to think that as long as there's some respect in that relationship, that it's simply a matter of saying, hey, I appreciate you putting this form together. I had some concerns, even maybe I looked at it with my attorney. That can be really helpful to say, yeah, my attorney doesn't want me to sign this. Find an excuse. Throw your attorney under the bus. Just say, I talked to my lawyer and they really don't like this part and I can't have it in this contract. Or you can throw me under the bus. I talked to the Entrepreneurial Legal Lab and they said this is a terrible clause in a contract. Anyways, but it's a matter of like, if you're talking business person, it's usually like, let's just be real. I don't like this and this isn't right for me. And I want this to be taken out. This is how I'd like it phrased. When one is working with another attorney on the other side, I would encourage you to be blunt, to not hedge, to not try to be too nice to the lawyer. Just say straight out what you think what you want and what you deserve. And lawyers are used to that. And they might actually appreciate that lack of fog, if you will. That said, I know it's really intimidating to do that. But I encourage people to just be straightforward and blunt with lawyers. They're used to it. They appreciate it. They may not have the ability to amend the contract. Their client might not let them, but they usually are a go-between to work out negotiations like that. Does that answer your question?
Yeah, I think it does. I'll just follow up and ask, is it better to put the request to change the contract in writing for any reason versus just verbally trying to hash it out?
From a lawyer's perspective, yes, it is, because that keeps that counter offer open. So if someone has a written contract and they email it over and then there's a verbal exchange, it's really hard to prove that verbal exchange for what should have been in the contract. So yes, putting in a writing, having a back and forth discussion in writing about what should go into the contract from a lawyer's perspective is going to mean that there's no obligation on the client's part until it's actually signed. If it's verbal back and forth, that might not be protected.
Thank you.
The law is weird and complicated, and I'm sorry about that, guys. Okay, Devin, you're next. How do you resolve disputes before court?
Yeah, I'll talk about a few ways of attempting to resolve disputes outside or before court. Businesses can resolve contract disputes outside of court in at least 3 ways: negotiation, mediation, and arbitration. These methods can be faster and less expensive and less adversarial than court proceedings. And when I say less adversarial, I mean less hostile and less combative. So I'll go through each of them. Negotiation involves discussions or communications with at least 2 parties with the aim of reaching a mutually acceptable outcome. It can be an agreement, resolution, solution. Some negotiations can involve lenders, vendors, leasors, mortgagees, service providers, clients, and anytime someone tries to work out a deal with someone else, that's a negotiation. And the same thing happens with contractual conflicts. It can be a generally effective method of resolving dispute and cost less than mediation, arbitration, or court. But it does require communication, offers in good faith to settle disputes, and minimal posturing or game playing. So with negotiation, one ultimately hopes to find a resolution to move forward or part ways, and the resolution is generally non-binding. With mediation, a neutral third party, a mediator, facilitates communication and negotiation between disputing parties, also with the aim of helping the parties reach a mutually acceptable outcome. The mediator doesn't make decisions or impose a solution, but facilitates and listens. But unlike negotiation, Mediation typically results in an enforceable contract, binding. So mediation can help those in dispute air concerns to a sympathetic ear, the mediator, and can result in creative solutions unavailable in court. And arbitration, it's more rigid than negotiation or mediation and more resembles court. Arbitration involves a neutral party who plays a role like a judge, an arbitrator, or panel of arbitrators. Usually evidence might be submitted, hearings might occur, motions might be made, discovery might occur. Arbitration seems like a lawsuit, but the process is private. Parties usually pay for the process, and the process is usually cheaper and faster to navigate than a lawsuit. Arbitration results in an award, theoretically enforceable, with some filing in the state in which one wants to collect. But sometimes disputes need litigated in court.
And of course, that's where I come in because I have done a lot of litigation in my life. This is something that's more comfortable for lawyers, unfortunately, and it's terrifying when you're a client or just a non-lawyer trying to go through a law case, a court case. In general, there's an overall process to a court case that most folks should understand. And I'm sorry, Simeon, you popped in. Did you want to ask a question about the alternative dispute resolution part?
Oh, I just thought it would be an appropriate time to kind of let folks know or remind them about the Attorney General's office and that they are a really helpful aspect if you are having a dispute, either as the consumer, you bought a product or service, or if you're a business that's having a dispute with another business. So just to remind folks that resource is out there. And if you go to our CVOEO.org website and navigate to the micro business classes, you can watch a previous class recording that we had with the Attorney General's office that kind of explains what they do. So that's it.
Nice. Yeah, they have the business mediation program. That's a great. Thanks, Simeon. In general, a court case is going to follow a fairly particular path. Usually there's going to be some part at the beginning where someone files a document. Usually it's called a complaint. That document in a civil case has to be served on someone. There's usually going to be a process where the parties are going to go through an information exchange called discovery. Discovery is intended for folks to discover what information the other side has, what documents they have, what are they holding that the other person might not have. There's typically hearings, which is just meeting with the judge, essentially, have both parties to a dispute, meet with the judge. That's a hearing. Sometimes hearings involve submitting evidence. Sometimes it's just a check-in, a status conference with the court. Typically there's motions in most lawsuits. Motions are just a request to the court to do something. It's hey, can I have more time to file? Or it's, hey, I think I should be given judgment and here's why. Or it's, hey, I want to change my complaint or I want to amend something because I made a mistake and here's where and here's what I want to do. Motions are just the way that business is conducted with the court. Requests back and forth. Orders and entry orders are typically the way that the court responds to those requests. They'll put an order in that says this is what the response is, or this is what we're going to do about this motion. And then of course trial. Trial is the scary part of litigation. It's what everybody thinks of when they think of court, and it's the process of being in a courtroom in front of a judge or a jury and people on the stand giving testimony. And it's actually extremely uncommon for any case to go to trial. About 95% of cases settle either in mediation or negotiation. Many cases go to arbitration, but it's very uncommon for a case to go to trial. So if that's any comfort to anyone who might ever have any litigation in your future, it's unlikely you're going to go to trial. Small claims, there's two options for filing a civil case, which is where contract disputes are filed in Vermont. They're filed in the civil division. There's two options. First, for a simplified process, there's the small claims court. This is a really great venue to resolve disputes that are under $5,000, especially because that's the cap. You can't file in small claims court if you're asking for more than $5,000 from another person. That $5,000, by the way, has to include any interest or costs or attorney's fees that you're claiming are owed by the other party. So for small claims up to $5,000, as long as the amount is below that, small claims court is faster. It's simple. It's less expensive. The filing fees aren't more than $95. It's informal. The rules of evidence they can be used, but it's really designed to be the people's court. It's where you can go up and you can present your case to a judge without needing to have a lawyer, and you can get relief, or you can get a judgment order for what you need. It is limited. There's the $5,000 cap. The options for being in small claims court are not as broad. That bothers attorneys more than it bothers anybody else, because we like to file motions and stuff like that, and you can't really file motions in small claims court. It's a really great option though for most people. It resolves so many disputes, and it's actually it's an easy process for people to go through. So Superior Court is the bigger one. This is typically where larger disputes land, bigger filing fees as a result, several $100s to file a case. It's very formal. There's steps to the process. There might be a scheduling order that's put in place that says, you know, must mediate by this date, must file motions by this date, trial ready by this date. There's no limit on the amount that can be claimed in Superior Court, but there's the formalities come into play. So definitely going to have to file a motion if anybody wants something from the court in a Superior Court case. It's going to be slower. Usually takes a couple of years to get through a court case in Superior Court, and it's going to cost a lot. This is typically where attorneys are going to represent clients. It's harder to navigate. The rules of evidence apply. The rules are more intense. It's just a little harder to get through it without legal training in Superior Court. But those are the options. It is possible to have a case that's heard in small claims too, that can be taken into Superior Court. That happens sometimes. And then just a note here too, if someone goes through a lawsuit and they get a judgment order and they're not happy with it, for small claims court, those can be appealed up to the Superior Court to say, hey, they got it wrong, I want a different decision. Or Superior Court decisions can be appealed up to the Vermont Supreme Court if someone disagrees with the court's decision. So that's litigation in general in court, just to describe the options. Does anybody have any questions about either one of the last two slides? Because that actually wraps up our presentation.
I have a question, but I'll defer to others if other people have questions.
Okay. Anybody else?
Take that as a good to go. You mentioned that that interest could be accounted for. If you're going to have interest, is that something that you would need to have spelled out in a contract?
Oh, great question. There is a default interest rate that applies. So actually, I have to reach back into my collections background for this. I'm sorry. If I remember correctly, if there is no interest rate, then the default interest rate is 12.5%. It might be 12%. On a judgment, interest collects at 10% automatically. Interest is something that doesn't have to be written into a contract. It's just an accounting thing. Typically, a debt is going to be principal and interest. If someone wants a higher interest rate than the default, yeah, they got to write that into the contract. So the 12%, if they want like anything above that, it's going to be in the contract. Otherwise, that's default.
Okay. And realistically, if you win a judgment in small claims court, in reality, what is the expectation in terms of collecting on that debt?
Oh, that's another great question, Simeon. Because there's a difference between getting a judgment and actually collecting on that judgment, which is what you said. A judgment is a piece of paper that says you win, and here's for how much. It's really all it is. You won the court case. This is what you're owed by the other person. Collection is very challenging. There's a couple ways to do it. There's always voluntary payments. If somebody is willing to make payments, obviously that works out. But if somebody is unwilling to make payments on a judgment, typically the payment sources are going to be insurance, if there is any. If this is somebody who got injured and insurance for some reason is not already involved, if there's a judgment, that judgment gets sent over to the insurance pay up. If there is, if somebody has the information for where the judgment debtor works or where they bank, there's something called a garnishment that can be filed. It goes by a different name in Vermont, and I'm sorry, I'm working off my Utah memories, but garnishment goes by different names. It's essentially saying, hey, employer, you're going to take a chunk of this person's taxes or this person's income after taxes, and you're just going to send it to us. You go through a court process to prove this is the amount of the judgment owed, this is where they work, and then the employer has to process with every payroll they'll take a portion of that person's paycheck and send it to the judgment creditor. There is also, if they have the bank account, similar process. They have to go through, get a court order that puts a freeze on the person's bank account. Any amounts are held in escrow by the court to see if there's going to be a dispute. Sometimes, maybe a debtor has a cosigner on the account, and that's some of the cosigner's money is in the account. They can object to that and say, hey, court, you only get to have this piece. But the rest of it typically can be taken to pay a debt. So wage garnishment, bank garnishment. There's something called a till tap in Vermont. This is where essentially someone who has a judgment, a court judgment, asks a sheriff to walk in and take the money out of the till. That's one way to collect. That has to be gone. That has to go through it. That has to have a court order too. But these are options. Beyond that, if there's no voluntary payment, there's the possibility if there's no voluntary payment and there's no way to garnish. If people own property, they can the judgment can be filed as a lien on that property, and if that property is sold at any point, that lien has to be paid off in order for the sale to go through. If there's other valuable things, people can attach liens to those to collect the debt, but those are basically the options. And if none of those work, if someone doesn't have property, they don't have income, they can't pay, they won't pay voluntarily, there's no insurance, that's where people walk away from a judgment and say, I'm not going to collect it. If they're not working, if they don't have a bank account, if they don't have land, they're judgment proof.
Will the interest rate at the rate that you mentioned accrue if with the say a claim of $5,000 or less in all those instances?
Yeah, post judgment interest rate is 10%, and the judgment is good for 8 years, and then it has to be renewed. So a judgment can actually be renewed perpetually every 8 years.
Yeah, that was going to be my question to you. Is like, does it? How long does the judgment hold for? It will eventually fall off like a negative on a credit report. Okay, well, they didn't collect and you didn't pay, so it's not enforced anymore.
Right. If the person who holds the court the court judgment does not renew it, then it goes away. If they file for renewal, it stays as long as they do that. I'm
sorry if these are kind of some odd questions, but
these are great questions. I love them.
Yeah. So if the person renews the lien or the judgment, I think you mentioned it as, would the defendant get an update that has been renewed by the court?
They would.
Yeah.
Yes, they would. So if they would be a party to the court case, and they would continue to get notices from the court case, and one of those would be the plaintiff's attorney or whoever it is filing for a renewal of judgment, and that would get sent to the debtor.
Okay.
Yeah.
You mentioned liens, and I wonder what the options are there for businesses regarding liens. I've heard of the term a mechanic's lien. I don't know if you can speak to those and to what degree they are options for businesses.
There is a statutory mechanic's lien. Unfortunately, that's all I know about it. So I know it exists. I don't know the circumstances under which a mechanic can apply a lien, but I believe it's for work done by a mechanic can be imposed until payment is received for those services. That is statutorily protected. There's other kinds of liens that other states might respect. One of them is something called a garageman's lien, somebody who leaves something at a vehicle at a repair shop and they never pick it up. The garageman can file a lien on the vehicle to try to collect and sell it so they can get recovery from hosting the vehicle basically on their lot. There are some, generally it has to do with the working trades. So construction, repairs, things involving tools and equipment, things like that. There's typically going to be some sort of anytime there's a service where there's expensive equipment involved basically, or a lot, or someone who's offering a service, there might be a possibility of putting a lien on there. That said, it's the only one that I know of for certain is that mechanic's lien. The others are sort of they're in the common law. And so someone could claim something and then it might get tested in court and who knows what's going to happen.
Yeah. Just a follow up to that. So in order to place a lien, do you need to have the judgment in your favor or can you?
Well, that's a good question. I think the mechanic's lien is actually pre-judgment. I don't have the answer to that though. I'm sorry, Simeon.
It's okay. Okay.
If they, but for a property lien, as long as the underlying judgment is valid and the creditor has filed to put a lien on someone's property, as long as the underlying judgment keeps being renewed, that lien stays good in
Mhm.
perpetuity. It has to be paid off if the property's sold.
Mhm. Okay. And with this topic, does credit ever come into it? Like, the reporting a debt that somebody owes, or
Mhm.
judgment against them. I imagine the judgment would come from the court, but what are the options for a business to report this to somebody's credit report? If something goes wrong
Right.
between.
If something goes wrong. So a business, there's the first thing to know is that one has to report to the credit bureaus in order for something to show up on someone's credit report. There's no automatic process for that. Second thing to know is that there's basically two opportunities to report. One is before a judgment that says that there is a claimed debt. One is after judgment that says there is a verified debt. So there can be hey, this debt is owed, but it hasn't been secured by a judgment. There can also be an indication on a person's credit report this is secured by a judgment. So I find it's very uncommon for business owners to actually do that.
Mhm.
To actually report to the credit bureaus to make that effort, but it's not that hard. And what happened, because the people who do collections do it, they'll have a mark put on a person's credit report. And I got to tell you, like, it sends them back screaming to the collector quite often. So that's a tactic business owners can use if they report to the credit bureaus before and after judgment. That just sits there, and it's gonna either sit there and it's gonna be there until it'll be there until it falls off. If there's no judgment, like you said, it just sort of goes away over time after 7 or 8 years, and it will be there forever on their credit report if there's a judgment that keeps being renewed.
Mhm.
But yeah, it's a really good tactic. If you have a debt that you're trying to collect, put it on someone's credit report. You usually hear from them.
And in order to do that, do you need to have a judgment in your favor, or can you just do that without having to go to court?
Yep. Think
Okay.
of unpaid hospital bills that
Gotcha.
pop up on your credit report.
Okay.
Those are not secured by judgment, but they can be reported.
Okay. Thank you. That's all I
Other
got.
questions? You asked the best questions, Simeon. Prentice, go ahead.
Yeah, I got confused about online sales. I was thinking of selling some crafts on Etsy. So do I need to have a contract, or how? I mean, I got scared. You
Right.
said you have to mention Vermont as to be the main.
Right.
I got confused basically.
And I apologize for that. I understand why you're confused. For a service like Etsy,
Mhm.
there's typically going to be terms and conditions and a policy in place that can't be modified. So anyone who is selling on Etsy is going to sign something that will probably be a click here if you agree, that says how they're going to host the product, what percentage they're going to keep, how disputes are resolved. It's just basic contract. And in there is likely going to be, if there's a dispute over any sort of a transaction on Etsy, this will be the venue where the court case will be heard. So that's something that likely anybody who's setting up an Etsy account to sell with, they're not going to be able to negotiate that because Etsy won't budge on it. But
oops. Okay, so if there's a dispute, could not be Vermont, could be somewhere else.
Yes, it could be somewhere else. But what I want you to take from that, Farnaz, is that if you're going through a service, that's going to be dealt with in their contract. If instead you're doing the direct sales yourself and not going through Etsy, for example, that's when there needs to be, if you've got terms and conditions on your website, that's where you need to look at the language of that. And if you want things to be held in Vermont, then you got to put it into those terms and conditions.
Okay, so for Etsy, I don't need to have a contract. It's all part of the program. I have to agree and it's done. I agree.
Typically.
Okay, got
Yeah.
you. And it looks like if I want to lease or if I want to have a contract, probably I need a lawyer. So how do you find a lawyer? What type of lawyer you need?
Great question. I'm sorry, I didn't go on to the last slide to give you the guys the information about our program. So, and I'll answer your question just a second, Farnaz. I've got the address up here that was at the beginning of the presentation. Also our email address, vsell@vermontlaw.edu. This is the services that we offer. We do individual educational consults. So this is what we're doing right now, sort of the group education events that we do. We also meet with you one-on-one for an hour to talk about questions that you have, give you background and information to help you understand the legal needs that you're facing. We also have a paid referral system with the Vermont Bar Association at no cost to you. We can find an attorney and pay for the attorney to serve with up to 10 hours of work for the business. So if you're looking for an attorney, I can help you find one if you wanted to submit an inquiry at that address that's at the top of the slide here. It just asks for you to describe your legal needs, ask some demographic questions, and then depending on what you select, it will go through to me, and I can then just send you to the Bar Association, find an attorney, or send you a link to say, do you want to schedule an educational consult? So that's one way to find an attorney through us. We'd be happy to help. Another way is word of mouth. And word of mouth can also mean working within one's industry. So I don't know what industry you're in front as, but if there is an industry association that might have resources or other members who you could ask who they've worked with before as a lawyer, that can often help. Sometimes industry associations will have that information on their website too, like this is the person that we work with. Word of mouth, talking to other people in your industry, talking to other people, other business owners that you're familiar with. There is a lawyer referral service with the Vermont Bar Association. You can look at that. That will find you an attorney who can help, and then you get a half an hour consult at $25 to start the relationship. And if you want to work with the attorney, you can go on beyond that. Most people don't charge that $25 because they don't want to try to collect it. So lawyer referral service will get you to someone also who can help you, and that there's that initial charge. And then finally, just Google. I don't want anybody to think that, with the exception of some very complicated transactions, most lawyers are going to be able to handle most contracts. There's some complicated stuff that that lawyers have to have specialized knowledge of, and I'm thinking of like investment setups, big deals where someone's investing and they maybe they need to set up some stock to be able to recover the value of that investment in the future. Complicated construction contracts, there's usually, you have to have very specialized knowledge to navigate those, but your everyday services agreements, waivers, leases, almost any lawyer is going to be able to look at that and give you a good solid opinion and give you advice on that. So I say that because there's a common conception that lawyers are hard to find because you got to find the one that's got the right amount of experience working with your kind of a business. That's not necessarily true. Can be true for specialized industries, things like the healthcare industry or licensed professionals, but it's often not. Often a lawyer is going to be able to do what you need to do regardless, because that's how we're trained.
You said 10-hour free consultation. You offer
For
that?
10 hours of services. That does not include litigation. So if you had to be represented in a court case, I can't cover that with my program. But my grant will pay for virtually any other advice if they'd have to draft a contract, to prepare documents, to negotiate a transaction. Even if someone's facing litigation, I can help them prepare for that process. I just can't pay for representation in court.
Okay, great. That's good. Thank you.
Any other questions, guys?
So, me, Professor Nicole.
Hi, Islanda.
Yes. So I think we already talked about the lawyer, and I'm just listening. And so I'm next on the list to find a lawyer, right?
Let's check in, Islanda. Yes, I've got you on my list.
Okay,
but
thank you.
let's talk about that offline, okay?
Thank you.
No problem. No problem. If there's no other questions, I guess we can wrap up.
One more last one.
Oh, you do have one last one. I'm sorry, Fernaz.
Okay,
Go ahead.
One last. Maybe I should watch that video. But Attorney General Office, can you? What do they offer exactly? I used them once because I went to a mechanic and they helped, but I was a consumer. But as a business person, how can they help me?
It's a mediation program, so it's helping everybody is the idea. It's if there's a dispute, to have the ability to have a free person to step in and say, okay, what's your concerns? What's your concerns? How can we mutually resolve that? That's the service in and of itself. So I would say feel free to use it as a business owner or somebody as a consumer.
Okay.
It's a great service. It's wonderful and it's free.
Okay, gotcha.
Anything to add to that, Simeon?
Um, No, not really. I guess other than to say that, if you're not getting somewhere with a business, they're not responding to you. I think it can be helpful to have somebody from the state of Vermont that sounds, very formal, reaching out to that business, and they may be more likely to respond if you're not getting anywhere.
Yeah.
I mean, they can't guarantee they can satisfy the situation, but they have a very good track record, and it's one of the most obvious places I can think to go before one has to maybe think about either losing out completely or finding a lawyer they have to pay for.
Yeah.
Thank you.
Good point.
Any other questions? Nope.
I see Callum's note in the chat. Awesome questions. Thanks, Callum.
So thank you so much, Nicole and Devin. Thank you
And
so
Brennan
much
and Devin.
for the presentation today. Obviously, it sparked a lot of questions and interest, and I think it's just an important topic that is helpful for folks either going into business or maybe in business and want to know more about. So thank you so much. And Sophia is going to be sending out some information to everybody today with a recording and some of the resources that were discussed and shared during the presentation, and also, Sophie, if you don't mind, also including in that information on our next upcoming class with the Vermont Law School, topic, day and time, what have you. So
Absolutely.
So if the presenters and Sophia don't mind just hanging out for a minute or so, that'd be great. Otherwise,